for all Virginians, no matter who they are and who they love. Thank you.
Thank you, Mary. We'll now hear from Tony London.
I would just like to say to everybody here that Tim Bostic and myself are truly in love. We have been together for a very long time, and this means a lot to our family. We are no different than anybody else out here. We just want the opportunity to be recognized the same way everyone else is and to have the same benefits that married couples have now. And we don't have those benefits, we don't have the rights. So we are looking very much forward to a positive answer from the judge, I hope. But thank you all.
Thank you, Tony. We also have here with us Tom Shuttleworth and Robert Ruloff, attorneys for the case. Tom, if you'd go ahead, I'd like to make a few remarks. Thank you.
I've been coming to that court that we were in today for 40 years, and like many of you who reported that court, you see people coming into court asking for money, asking to be kept out of jail, asking, but always asking. And it struck me that today, these people just want to get married with dignity, and they're not really asking for anything that everybody else doesn't already have, and they ought to be granted that. Thank you.
Thanks, Tom. We also have with us here Attorney General Mark Herring.
Good afternoon, and thank you all for coming. Today was a significant day in the journey toward full equality under the law for all Virginians. I'm proud to say today that the Commonwealth of Virginia stood on the right side of the law and the right side of history in opposing this discriminatory ban. This was also a good day for the rule of law in Virginia. Despite claims to the contrary, my action in this case has not ended the marriage ban, nor has it ended the court case, nor does it mean the marriage ban is not being defended in court. This case is fundamentally about whether Virginia can legally treat same-sex couples as second-class citizens, or whether the United States Constitution truly guarantees equality under the law. This case is also more than an abstract legal debate. This debate affects the lives of thousands of Virginians who are our friends, our neighbors, co-workers, parishioners at church, our brothers and sisters, and they deserve to be treated exactly the same way all other Virginians are. Today, Judge Wright Allen heard Virginia's Solicitor General, Stuart Raphael, make a compelling case on behalf of the Commonwealth of Virginia that the state's marriage ban violates the 14th Amendment to the United States Constitution. She also heard Mr. Olson and Mr. Boyce speak eloquently for their clients in arguing that Virginia's ban should be struck down. And counsel for the defendants in this case did their best to defend the constitutionality of the ban. None of those arguments were new, and I had considered all of them, many of which were advanced in the brief filed by my predecessor, Mr. Cuccinelli, and I still find that their arguments fail to meet even the most deferential legal standard, let alone the heightened scrutiny that is required when fundamental rights such as marriage are at issue. In recent weeks, my decision to change the state's position in this case has drawn some criticism from predictable corners, though none of that criticism has focused on my legal conclusion regarding the constitutionality of the ban. And I think that's because, as you saw today, the legal arguments in support of the ban are weak at best, and in many cases have previously been rejected by the courts. One cannot help but notice that the loudest critics have been those who are most vehemently opposed to treating gays and lesbians as equal Virginians. Although we have much to be proud of, there have been times when brave Virginians have led the fight for civil rights while their state leaders have stood against them. Whether it was the right to public education, regardless of race, in Brown versus Board of Education, or the right to marry the person you love regardless of skin color in the Loving case, or the right to attend state colleges and universities regardless of gender in the VMI case, Virginia has too often found itself on the wrong side of landmark civil rights cases. The injustice of Virginia's position in those cases will not be repeated this time. And today, the Commonwealth of Virginia got it right.
We'll also have brief comments from Robert Ruloff, counsel for plaintiffs.
Thank you. Immediately when Ted Olson finished speaking, I jumped up and said, I've been a lawyer for 40 years, and this is probably the greatest moment in my life as an attorney because the importance with which his case was handled and the passion that he and Mr. Boies, and also the American Federation for Equal Rights. We have people here from California. We have a lawyer who helped write the brief from Dartmouth. I'm a coal miner's son. We have people all over the country here for this case today. So how did this begin? Why are we here? How did we get here? Tony London and I were talking one day when the Prop 8 case was just held as the constitutional law in California is unconstitutional. In the Prop 8 case, these lawyers did a good job in maintaining California's right to equality. But in talking to me, Tony said, I'm going to go to Maryland and get married. I said, Tony, you don't need to go to Maryland to get married. We can get married here. He said, not in Virginia, not in Virginia. That'll never happen. I said, well, let's just try and see what we can do. He said, if you're up for it, I'm up for it. I go to Tom Shuttleworth, and Tom says, let's try it. He goes to Tim Bostic, let's try it. We filed for our marriage license in Norfolk, we're denied. But we filed our case because these guys had the courage to take this case and fight this fight for other freedom. Our phone rings. Matt McGill's on the phone talking to Eric Piccaro about our case. He says, we will join you. Now, I'm a transactional lawyer, not a litigator. So Tom Shuttleworth explained the importance to me and Charles Lustig of having Olson's firm in our lawsuit. I said, wow. Then David Boies wants to join our lawsuit. I go, Tom tells and explains to me why that's better. Then I said, wow, what a team. Then Adam Umphofer, is that pronounced right? Where's Adam? Is that correct? Adam Umphofer calls from California and say they want to join our case. So what does that mean? That means our case is not a Virginia case. Our case affects all gay and lesbian people in this country. It's not Virginia East Coast. It's not West Coast. Our case is where the East meets the West. That's what our case is about. We have a Republican attorney up here, prominent Republican attorney. A Democrat is here. So this is not a political case. This case is about a basic human right, the freedom of choice. A philosopher once said, a Roman philosopher, that many of our loves and passions are a geographical accident of birth. For example, you love your daughter, you love your child, but those are geographical accidents. But when you choose to love someone, that choice is far more significant. It's not cast upon you. It's something that develops when you see a person, an affinity. So, to deprive that person of that choice is to deprive them of a very fundamental human instinct to love another person. Who are we to dictate, I'm straight, but who are we to dictate to the lesbian community, the gay community, what they should do and who should they like or who they should marry? That's not a right we have. We're not meant to do that. So, this case is very important because it involves different issues. Tony and Tim want to be married in Virginia. Kill and Mary want their marriage to be recognized in Virginia. Their daughter doesn't want to be less than equal. And with regard to children, it's a shame to know, and I will share with you, Tony and Tim wanted to have a child. But Tim said, we can't do that in Virginia because we won't be able to adopt. Tim's words to me last Sunday, I wanted to have a part of Tim with me. They would have a surrogate mother carry the child. They decided that door was shut. So when Tim found the doors open to marriage, he got excited, and he now feels he might be recognized as a complete, equal human being, not a second-class citizen in this country. With regard to religion and the equation, the representative from Hawaii made a very important observation and comment when Hawaii passed this law. He said, how many gay people does God have to create before everyone accepts He wants them here? How many gay children must be created, these are my words, not his, before we all accept the fact we're all children of God? So who has a hotline to God to say what's right or wrong? We're all children of God. That's it. And in conclusion, one philosopher associated the basic needs of human beings as follows: the bird, the nest, the spider, the web, the human relationship. Thank you.
We now have time for a few questions. Yes.
My question regards the one difference I noticed between what Mr. Olson and Mr. Boyce argued versus the Solicitor General's argument, and that's for the injunction, and how soon it would be applied. Could you explain the difference in your thinking, and would it matter to you, Mr. Bostic, regardless?
Yeah, that's more for the attorneys.
I think the difference between us is in terms of whether you think a preliminary injunction of the type that we asked for, which we think is a very narrow injunction, is something that could be effectuated without additional consequences. I think probably the Solicitor General would agree that if we could have a preliminary injunction that gave equal rights to these 4 plaintiffs immediately, without further implications, that would be a desirable thing. I don't want to put words in his mouth, but I suspect that would be the case. The question is whether by granting preliminary relief here, would that sort of open the door to a lot of additional litigation. We think that would not be necessary. The Solicitor General is concerned about it, and I think that's really the difference.
Yes, my question is for the Attorney General.
Could the Solicitor General weigh in real quick?
My question is for the Attorney General. Mr. Attorney General, although your most outspoken critics in this matter are those who are opposed to the same-sex marriage, there are those who feel like you have betrayed a public trust, that your oath of office was to defend the laws of Virginia and the Constitution. And in that definition of your job description, nowhere in there does it say if you agree with them. How do you reconcile that in fact you are upholding your oath with it?
Well, the oath of office that I took was to support the Constitution of the United States and of Virginia. And as we're taught at a very young age, when the two conflict, it is the U.S. Constitution which must prevail and is the law of the land. An Attorney General has a duty to defend those laws that are validly passed and that are constitutional, but an Attorney General has an equal duty to not defend those laws which, after a thorough and careful and rigorous analysis, he concludes that it violates that Constitution. So I am fulfilling my duty, and it is the U.S. Constitution which prevails where there is a conflict with the state Constitution.
Just a quick follow-up to that. Many are wondering why that wasn't a part of your campaign, why this belief of yours wasn't heard during the campaign.
The process that I followed was, as soon as I appointed Solicitor General during the transition, knowing the scheduling of this case was proceeding, I tasked him with heading up a legal team to review the analysis